guys, welcome to Wickedly Judged, the podcast dedicated to exposing wrongful convictions and fighting for justice reform in America. I'm Rebecca, your host, and if you're new here, this show is for anyone who believes that justice isn't just a verdict. It's a promise, a process, and far too often, a fight. Here at Wickedly Judged, we shine a light on the cracks in our justice system by sharing the real stories, true life of those who have been wrongfully accused, convicted, and forgotten by the courts. We give a voice to their families, advocates, and survivors who refuse to accept injustice as the end of their story. Before we dive in, a quick thank you to our sponsors, Veteran Alliance, Yarn Therapy for Me, Justin Apron, Liberty First Radio, NDVLB, Prime Ledger Group, JSIL, and Wickedly Judged Justice Activation Project. And a special thanks to JP Verse of Versefire Records, providing our powerful intro and outro music. Your guys' support fuels our mission. Thank you so much for standing with us in the fight to expose wrongful convictions and demanding true justice in America. In the first two episodes of this series, we talked about the contradictions surrounding the knife, the conflicting witness narratives, the missing weapon, the archived records, and the constitutional concerns raised throughout the motion for leave. But tonight, I want to talk about something most people do not understand until they are forced into the middle of it themselves: the appellate process. Because one of the biggest misconceptions in America is that if someone is wrongfully convicted, the courts will simply fix it. People imagine dramatic courtroom scenes where one attorney stands up, presents one explosive fact, and suddenly everyone in the room realizes what a huge mistake was made. That is not how this system works at all. The reality is much colder. Most wrongful conviction litigation happens quietly. It happens in late nights, stacks of transcripts, public records requests, procedural rules, rejected filings, missed deadlines, constitutional arguments, and years of trying to convince courts to even look at issues families believe were never fully examined. And one of the hardest things families learn is this: courts can reject claims without ever deciding whether the person is innocent. That is one of the most important things I need my listeners to understand tonight, because appellate courts often begin with procedure, timing, preservation, jurisdiction, standards of review, filing requirements, procedural bars, whether the issue was even raised before, whether it could have been raised before, whether the court is even allowed to consider it now. Not necessarily whether the underlying concerns are emotionally compelling. Not necessarily whether the family has uncovered contradictions, not necessarily whether something feels deeply wrong. And that is not just a feeling families have. National data shows how difficult appellate review can actually be. According to the Bureau of Justice Statistics, in a study of criminal appeals resolved in state appellate courts in 2010, courts affirmed the trial court decision in the majority of cases reviewed on the merits. Only a small percentage resulted in reversal. That means appeals are not a simple second chance. They are a narrow, technical reviews governed by strict rules. And for families, that can be devastating because they may believe they have uncovered serious problems, but the court may still focus first on whether the issue was preserved, whether it was raised on time, whether the correct procedure was used, and whether the court has authority to consider it. So when people say, "Why didn't the appeal fix it?" the answer is often much more complicated than people realize. Sometimes the issue is not whether the concern matters. Sometimes the issue is whether the system will even let that concern through the door. And once you are living inside that reality, it is devastating because you realize the fight is not only about truth, it is also about whether the system will allow the truth to be heard. I think the best place to start is by explaining what a direct appeal actually is. Because most people hear the word appeal and assume the appellate court simply retries the case. They imagine new witnesses, new evidence, a fresh courtroom, a second chance to tell the whole story. But that is not usually what happens. A direct appeal is generally a review of what has already happened in the trial court. Appellate court reviews the official record. That means they look at trial transcripts, objections, rulings, exhibits, motions, jury instructions, and the proceedings that were properly preserved. That is why a complete record matters so much. The appellate court is not starting from scratch. It is looking backward. And if something is not in the record, or if something was never transcribed, or if important materials were never meaningfully placed before the review court, then the review itself can become limited. That becomes incredibly important in this case. Because one of the major constitutional concerns raised in our motion for leave is that important proceedings and materials remained inaccessible for years. Preliminary hearing proceedings remain untranscribed. Archived recordings had to be recovered. Witness materials and investigative reports had to be pieced together through extensive public records efforts. And once those materials were finally reviewed side by side against the trial transcripts, serious inconsistencies became much more apparent. That matters because appellate review can only be meaningful if the reviewing courts have meaningful access to the full record. If portions of the record remain buried, archived, undiscovered, or untranscribed for years, then serious questions arise about whether prior review proceedings ever had the full picture. And for me, That realization changed everything. Because this was no longer just about a disagreement over testimony. It became a question about whether the case had ever been reviewed with all the critical materials in front of the court. Another thing most people do not understand is what happens after a direct appeal ends. Because many people assume that if an appeal loses, the case is simply over forever. But in wrongful conviction litigation, that is often when the hardest part begins. After direct appeal, families may enter the world of post-conviction motions, delayed appeals, habeas corpus petitions, newly discovered evidence claims, motions for leave, and constitutional litigation. And every one of those paths has a different set of rules, different deadlines, different burdens, different standards, different procedural traps. And if you do not understand those systems, courts can deny claims before ever reaching the underlying constitutional issue. That is one of the most emotionally devastating realities of post-conviction litigation. Realizing that truth alone is not enough. You also have to survive the procedure. And this is the one reason why wrongful conviction cases can take so long to resolve. The National Registry of Exonerations reported that people exonerated in 2025 lost an average of 14.2 years to wrongful imprisonment. In total, those exonerees lost more than 1,300 years combined. Think about that. 14 years is not a filing delay. 14 years is childhoods missed, parents aging, children growing up, birthdays, funerals, holidays, ordinary dinners, and entire seasons of life that can never be returned. That is why procedure matters so much, because when the process delays meaningful review, the consequences are not abstract. They are measured in years of human life. You have to know which claim belongs in which filing. You have to know whether the issue is considered new. You have to explain why it could not have been raised earlier. You have to show why the court should consider it now. And when you are an ordinary family with no legal background, trying to navigate all of this while emotionally drowning, it becomes overwhelming very quickly. Because the system does not slow down just because you're grieving the loss of freedom. It does not explain itself just because you are desperate. And it does not become easier just because the stakes are someone's life. One of the most important legal developments in this case was the filing of the motion for leave. And I want my listeners to understand what that phrase actually means. A motion for leave is essentially asking the court for permission to proceed. That may sound very simple, but legally, it is extremely important. Because when issues are raised later in the process, the court does not automatically review them. You usually have to explain why the court should permit the filing and why the claims deserve consideration. In this case, the motion for leave became necessary after later discovered records, archived proceedings, witness statements, and investigative materials revealed broader constitutional concerns. But discovering those concerns years later does not automatically open the courthouse doors. You still have to explain why the materials matter, why they were not previously accessible, how they affect reliability, how they connect to constitutional issues, and why review is necessary in the interest of justice. That becomes incredibly difficult when preliminary proceedings remain untranscribed for years, or when investigative materials were archived in ways that made them difficult to even locate, or when witness statements were only later discovered and compared directly against trial testimony. And once I realized how much of this case had never truly been reviewed together earlier, the constitutional concerns became impossible to ignore. Because this stopped feeling like a single procedural request. It became a question about whether meaningful review had ever truly occurred at all in this case. At one point during this process, communication with prior counsel broke down, and I eventually realized something terrifying. If this case was going to keep moving forward, I was going to have to learn how to navigate parts of this system myself. I never expected to spend my nights reading appellate rules. I never expected to study constitutional law. I never expected to compare transcripts line by line against witness statements, interrogation materials, and investigative records. But once you believe someone you love may have been wrongfully convicted, you either learn how to fight or the system keeps moving without you. So I started studying Ohio appellate procedure, evidence rules, wrongful conviction cases, public records law, habeas litigation, transcript analysis, standards of review, motions, deadlines, jurisdiction. And then I started comparing the records. Witness statements, preliminary hearing testimony, trial transcripts, police narratives, interrogation notes, recovered investigative materials. And the deeper I compared them, the more inconsistencies stood out. At first, you try to explain them away. Maybe it is a typo. Maybe someone misspoke. Maybe somebody remembered something differently. But eventually, the contradictions stop feeling minor because they involve central issues. Who possessed the knife? Who disposed of it? Where were witnesses standing? Who could actually see what happened? What people claimed earlier compared to what they testified to later. And that is when the emotional weight becomes overwhelming. When you see it lined up side by side, you wonder how the jury never even thought about reasonable doubt. This prosecutor did not prove his case and prove guilt beyond a reasonable doubt. You realize you are no longer just reading a case file. You are asking whether a conviction can actually withstand scrutiny. People outside this world of constitutional litigation and post-conviction litigation rarely understand how financially devastating post-conviction litigation becomes. Every transcript costs money. Every filing can cost money. Every expert costs money. Every investigation costs money. Every public records process takes time, persistence, and often more money than the families expect. And those costs are not small. The Innocence Project notes that DNA testing alone can cost anywhere from $5,000 to $50,000 in a single case. And that is just one piece of evidence. That does not include attorneys, investigators, transcripts, travel, experts, records requests, or the emotional cost of spending years trying to prove something the system has already decided against you. For most families, this is not just a legal battle. It becomes a financial emergency, and many families are forced to make impossible decisions about how much more they can spend, how much more they can borrow, and how long they can even keep going. These battles continue for years, sometimes decades. Most families simply cannot afford it, and eventually, many people run out of money long before they run out of questions. That reality is one of the biggest reasons organizations like the Wickedly Judged Justice Activation Project matter. Because families need education, resources, guidance, investigative support, help understanding records, help understanding the procedure itself, help understanding what questions do I ask next. Otherwise, many cases simply disappear into procedural history. Not because the questions were answered, but because the family could not keep carrying the burden alone. And once I understood how overwhelming this process truly is, it changed my life permanently. Tonight's episode was about the appellate process, the motions, the procedural barriers, the standards of review, the delays, the financial devastation, and the reality families face when trying to challenge convictions. Because wrongful conviction litigation is not just about discovering evidence, it's about getting the system to even consider it. In the next episode, we are going to turn directly to the investigation itself, the witness interviews, the evolving narratives, the interrogation process, the missing weapon, and the speed with which investigators appeared to settle on a theory. Because once you begin examining the investigation closely, the reliability concerns become even harder to ignore. Don't let these stories end just because this episode is over. If you believe in the work that we're doing, here's how you can help us right now. Follow Wickedly Judged wherever you listen to podcasts. Share this episode with someone who cares about truth and accountability. Follow us on social media. Leave a review. It's one of the fastest ways to help more people find these cases. If you happen to share a post on social media, tag us so we can thank you and amplify the conversation. And if you're able to support the mission directly, please donate to help fuel our investigations, advocacy, and education efforts. Or support the work by grabbing merchandise at wickedlyjudged.com. Every share, review, donation, and purchase helps us keep pushing for real justice reform. As always, stay informed, stay vigilant, and stay hopeful, because nobody deserves to be wickedly judged.